Right, folks, we're letting folks in here and have quite a few that have registered. So if you want to hold on just a few minutes, we'll get started shortly. You are just tuning in. We've got folks still filtering in, and we'll get started in just about a minute. Thank you for joining us today. All right. Well, I think we're going to go ahead and get started. Thank you, everybody, for joining us. Really important topic today. Want to share with you some updates on the Earned Sick Time Act, or ESTA, ESTA, as you might see it referred to here and there. And this is a presentation that is really heavily based on, it's what we know now, it's what's in law now, and also the reason that we wanted to do this presentation for you today is because the state issued new FAQs, or frequently asked questions. They amended some old frequently asked questions as well. And so we want to bring you up to speed on everything that we know now. I also want to add kind of a caveat that this is a very live issue in the legislative process. So right now we are in a period that's called lame duck. So after the election, before the new legislature is seated, the old legislature is still in effect, and they've got a few weeks of legislating to go. We are hoping that they will make some changes to some of the things that we're covering today, but with the deadline looming, we want to make sure that you are up to speed on everything that we know and that you're prepared to go live for this on the effective date. All right, so let's get into the presentation here. The first is just a quick background that that this issue, if you're just kind of tuning in recently, you might wonder, like, where'd this come from? I didn't remember this going through the legislative process. Well, that's because this came from a court decision. So this has been slowly moving its way through the courts. It's based on something that happened in the legislature in 2018. In 2018, there was a citizens initiative that was put before the legislature. They adopted it and then amended it, and we've been living under that system ever since then. Well, the Supreme Court said, hey, you know that amendment you made back in 2018? We're going to disallow that practice. And therefore, the original proposal, as it was presented to the state through a petition, automatically goes into effect. And so it was a close decision. It was a 3-4 decision at the Supreme Court, but unfortunately, the employer side lost on this case. And so this has gone into effect. Our big first point to make is that the effective date is on February 21st of next year. So that deadline is looming. It's just around the corner, but you don't have to actually change anything until then. You need to know what the rules are. You need to get ready for changes. But if you can hold off on changes for at least a couple more weeks, I'm going to recommend that you do, because I think there's at least some chance, actually a hopeful chance, maybe even odds chance, that the legislature will change some of these things. So we're going to get into what those things are and what we're most concerned about. But there's 3 big categories that you should be aware of. First is that this change in the Supreme Court by the Supreme Court will require a series of increases in the minimum wage. Right now, minimum wage is $10.33 an hour. Under current law, it's going to go up on January 1st, and then it's going to go up again because of this court decision on February 21st. So minimum wage is part of it. There's a change to the tipped wage credit. Under a current law, that will phase out. This says on there, you notice on that second bullet point, it says 38% of minimum wage, but that 38% will be gradually increased till it gets to 100%. And so what that means is that bars and restaurants, so the main entities that utilize tipped wage systems, that that eventually they'll just be under the regular minimum wage system, which is something that will be a huge upheaval in the industry, something that will likely put many, especially smaller restaurants, out of business. And so this is something that's an active discussion as well to preserve the tipped wage system, especially since employees overwhelmingly prefer the tipped wage system rather than being under the regular minimum wage system. And then we're going to spend most of our time today on very complex changes in paid sick leave benefits. And it's not just what you have to provide, but it's how you have to provide it and limits on how you manage your schedule and workforce in the future. So let's talk specifics on what these changes will mean. You'll notice on the left side, that was back in the 2018 proposal, there was a series of minimum wage increases in a schedule for them. And so that's on the left-hand side of this slide. Now over on the in the middle, you see the new wage and some new dates, 2025, 2026, 27, 28, starting at 1248. What that is an inflation adjustment to the original schedule. So what the Supreme Court said was, hey, the original increases to minimum wage, those were already supposed to happen in the future. So the cure for that was to say, all right, set those four-step increases in the future and adjust each one by inflation. Well, inflation was a lot in the intervening years. And so that inflation adjustment was almost 25%. So as of February 21st, 2025, the new minimum wage will be $12.48. So you're going to have like a two-step increase here. I want you to be ready for it. It's going to go for right now, it's $10.33 an hour. On January 1st, it's going to go to $10.56 an hour because there's just a regular annual inflation adjustment that was already in law. And then this court decision kicks in on February 21st, it'll go to $12.48. And then every year at February 21st thereafter, it will go up again. This is current law, okay? This is the Supreme Court and the Department of Labor. Everybody's confirmed that this is what the law says right now. The legislature could make an amendment to this, and there's at least some chance that they will. But if they do, it won't be downward. If there's an amendment to the schedule that you see on your screen right now, it will be for minimum wage to hit $15 an hour faster. Right here, it hits about $15 an hour in 4 years. If they change it, it'll be so it hits it in 3 years or 2 years. Okay, so this is the schedule at the moment. There's definitely folks in the legislature right now that are wanting to speed up this schedule. So from the employer perspective, it will not get any better than this. Unfortunately, we're very much in a defensive posture at the moment in terms of how aggressive they are in some of these items. All right, so these are the more straightforward things. Let's talk about paid sick leave. The current law, there is, you might maybe know this, maybe you don't, but there is a requirement in current law to provide a paid sick leave benefit. But that requirement only applies to businesses that have 50 or more employees. And this is something that it's a law that's a lot easier to meet than it's going to change to, because it only applies to full-time workers. You can use overall paid time benefit, your overall PTO banks to meet this requirement. It's a very flexible and relatively easy to meet requirement. What it is changing to, though, will apply much more broadly and will be much more specific, and it has a much more administrative burden and risk to employers in how they operate it. So there are a couple of categories. Okay, so you've got businesses with 10 or more employees, and then strangely, this law defines small businesses as 1 to 9 employees. It's the most restrictive small business definition I think I've ever seen. So you are a big business if you have 10 or more. You're a small business if you have your 1 to 9 employees. So they split the business community into 2 parts. So 10 or more employees, here's how your system works. It's an accrual base. For every 30 hours that your employee works, they earn 1 hour of paid sick leave. You cannot put any cap on how much the employee can accrue over the course of the year. but you can put a cap on how much they can use. Whatever they can accrue unlimited, 1 hour for every 30 hours worked. They can use up to 72 hours in any particular year. You never have to let them use more than 72 hours. So that's 9 days. That's a lot of sick leave when you consider we're not talking about vacation time. This is just for paid sick leave. The for the businesses that have 1 to 9 employees, you also have to be you also have to keep track of accruals, but it's a different accrual basis. 1 hour for every 40 hours worked if you're 1 to 9 employees, and you can put a cap on the paid sick leave benefit of 40 hours a year, 40 hours per year. But then you also have to provide 32 hours of unpaid sick leave. So it's total sick leave is still 72, but for 1 to 9 employees, have said only 40 of it has to be paid. Okay, so we're going to get into a lot of FAQs now, and on these frequently asked questions, they are verbatim what is on the state website. So it's the question and the answer, and we're going to get into all the how-tos on this. Okay, we're going to get into what these questions are, what the questions really mean as they lay them out, and the answers. And I'm going to really highlight the things that I think are either not clear, the things we need further answers on, and the things that I'm a little bit concerned that people might misinterpret. So we will, just to let everybody know too, because I see some questions coming in, I will take questions at the end. A lot of them are going to be answered in the presentation. Also, these slides are going to be available and the recording available on our website for your review later on. Okay, and also we have an email, sbam@sbam.org. If you'd like to email us a question that maybe we don't get to today, we'll do our best to answer it. And also, if you are a premium member or higher at SBAM, there's a service called Ask an Expert. And we have professional HR people behind this. And so it's one of your benefits as a member. Please take advantage of it. If you're a premium member, Ask an Expert is a service that is available to answer questions on this as well. Okay. What employers are covered under the Act? So they changed this in the FAQ to make it a little bit more clear. But it's really all employers except for the U.S. federal government. So the U.S. federal government is exempt because state laws cannot dictate the terms of the U.S. federal government employment. But everybody else is covered. For-profit, nonprofit, big business, small business, government, hospitals, emergency rooms, police departments, anybody who has an employee, is covered under this act. And so they draw kind of a bright line on it that for employees, or like which employees are covered, but the employers covered by the act are basically all employers who have any physical presence in Michigan. So if you have a physical presence in Michigan, you're covered by the act, at least as it pertains to those employees that are located in Michigan. All right, so the first thing we're going to get to is how you count to 10. If you remember, there's a different standard. The accrual basis and the cap, the annual cap, is different if you're 1 to 9 employees or if you're 10 or more. And so they did make some changes to this compared to the previous FAQ that we've given presentations on in the past. So this is basically who counts when you're counting to 10. And here's your kind of overarching rule. You're counting heads here. You're not counting full-time equivalents. So if you got a part-time worker, yep, they count. Got a seasonal worker, in most cases, they're going to count. You got a full-time worker, they definitely count. Even if you have a temporary worker, somebody that's like through a temp service agency, they count as well. In terms of, do you have to provide the 72 hours or the 42 hours? Is your accrual 1 to 30 or 1 to 40? That depends on whether you have more or less than 10 employees. And when you count to 10, it includes basically everybody. So I want to make sure that that you understand, like, the one kind of caveat to that is that it's anybody who's in your employ for 20 or more work weeks, and they don't have to be consecutive work weeks during a particular calendar year. So if somebody is on your payroll or doing work for you, even if they're through a temp agency, for 20 weeks or more, then they count as one of those people, whether they're seasonal, part-time, full-time, all of it counts. So once you hit that threshold of 10, you are in the more aggressive accrual, 1 hour for every 30 hours worked, but you don't, and then capping out at a use cap of 72 hours per year. All right. Now this next one, the question is what employees are eligible? And they made, this is basically the same answer as the state gave before. They did make it, I think, a little bit more clear in the answer. So it's been adjusted somewhat. But basically, there's a bright line on this. Okay, so anybody that you have to collect and remit federal income taxes. So think like FICA and that sort of thing. Like if you're, if you have a person that is doing work for your company and the law says that you must collect and remit federal income taxes, they are eligible to receive this benefit from you. So what does that mean in terms of 1099 contractors? If you pay somebody on a 1099, you may remit federal income taxes for them, but actually you don't have to. The law doesn't require that you have to. And so what that would say is that 1099 contractors, they're not eligible to receive the benefit from you. How about temp workers? You're paying temp employees that are you're paying a fee to somebody else. You're not collecting and remitting any income taxes at all for those employees because they're temp workers or somebody else's employees that you're essentially renting. In that case, you are not the one who is providing the sick leave. They're still eligible for the benefit, but it's the temp service that has to provide the benefit to them. It's still going to affect you, right? If they use sick time and use accrued time and they can't show up to work for you, it still could have impacts on you. But temp workers are eligible for the benefit, but they're eligible for the benefit from the entity that is collecting and remitting the income taxes, not from you. So anybody you are collecting and remitting income taxes for, they're eligible to receive this benefit, and you are the provider of that benefit to them. Okay. And then keep in mind too, actually, Sarah, go back to that previous slide, because I think this always comes up because it's so radically different from different practices. People will naturally question this. Like, could this really apply to a part-time worker? Could this really apply to a seasonal worker? The eligibility has nothing to do with how much they work for you. They could work for you 1 hour a year. And even if they only work for you 1 hour a year, if they are an employee and you are collecting and remitting federal income taxes on them, they're eligible for this benefit. You have to do the accrual. And so the red line has nothing to do with how much they work for you. Whether they receive this benefit from you is solely and individually, with no other factor whatsoever, are you required to collect and remit income taxes? So if you ask on part-time employees, do you collect and remit income tax on part-time employees? You do. Therefore, they're covered. They're eligible to receive this benefit. I mean, you are mandated to provide under this law this benefit. Okay. This does, and it applies to literally every entity. If you are an employee of somebody else, whether it's government, the federal government is the only exemption. This is schools, daycares, fire departments, police departments, hospitals, townships, cities, state government itself, nonprofits like SBAM, every single for-profit that has any employees, every single entity out there, except for the U.S. federal government, is subject to this law. Okay. What employees are eligible? So it is who's collecting and receiving. Next slide. When does an eligible employee begin to accrue sick time? So I want to make sure that we draw a distinction here, the difference between eligible to accrue and when they can start using it. These are two different questions here: eligible to receive, and when you can and when you have to start accruing. This answer says you have to start accruing on day one. After this goes in effect, there's no there's no period of time where you can say, well, I'm going to try this employee out for 90 days and see if they if they work out, and if they work out after a 90-day trial period, then we'll start accruing the benefit. No, the law requires that you have to accrue the benefit on day one. You have to accrue the benefit on day one of their employee with you. That doesn't mean they can start using it on day one, but you have to start the accruals on day one of their employment with you anytime after February 21st when this goes into effect. Okay, next slide. So we talked about like 72 hours of benefit per year, that you can limit the amount that somebody uses to 72 hours per year. How do you define a year? This is one where they give the business the ability to define the year however you want to define it. So a benefit year is a regular and consecutive 12-month period of your choosing. So you can say, I'm going to make it the calendar year. You can say, I'm going to reset it every on the anniversary date of this employee's hire with us. You can, if you have a fiscal year that's different, you can use that. It just has to be regular and consecutive. As long as it's regular and consecutive, you decide when that 72-hour or 40-hour cap for 1 to 9 employees, or 72-hour cap for over 10 employees. You decide when that annual kind of cap reset starts and ends. Now, an employee may carry over unused sick time. Okay, not just may, you must carry it over. The law explicitly requires that any unused sick time is carried over to the next period. So so I want to give a couple of different scenarios here. So you probably have some employees that whatever time that they have, they're going to use it. And then you have other employees that they never use it. You know, the time accrues and they don't use it, and it just kind of rolls over. What this law says is that any unused time must carry over to the next year. So if somebody, let's say you have a worker and they accrue 80 hours of sick time, because remember, you cannot limit the amount they can accrue. But the law says you can limit, they can say they can only use 72 in any particular year. So you limit it to 72. They use all 72, but they accrued 80. So you got these other 8 hours. You must carry the 8 hours over to the next year. The regulation that they put out says that you cannot even choose to pay them out on it to avoid carrying it over. The only option is it must be carried over to the next year. And so when you have employees that don't use it, it's gonna like that full amount might carry over, and you can see how it could just build up, because next year they might have twice as much, but they can never use more than 72 hours in a year, no matter how much is accrued. So somebody might accrue an unused hundreds of hours of paid sick leave, but in any given year, 72 is a cap that you as the employer may put on it. You can let them use more than that, but you don't have to. All right, so the next slide, may an employer provide the total amount of earned sick time all at once? So this is an important question. I've seen this pop up already in the questions here. And I think I'm seeing the questions as they do pop up, and I think a lot of them are going to be answered as we go through these states' FAQs here. So what about front end loading? This is like, you know, if somebody can use 72 hours, 72 hours is the most they can ever use in a given year. Can't the employer just give them 72 hours in the front end and then just forget about all this accrual complication? And the answer is no. Like, yes, you can front end load. No, you can't skip the accrual. So even if you front end load, what the state is saying is that, yeah, you can front end load at 72 hours, but employees are entitled to accrue more than 72 hours, even if you limit how much they can use by 72 hours, and as the law allows you to. So what the state is saying is, no, you still have to do the accruals, because what if they ended up earning 72 or 74 or 78 or 80 or 100 hours in a particular year? So yes, you can front end load. No, you cannot skip accruals. This is one of the things that we are explicitly asking. We don't think it's a very big ask of the legislature. we'll get to our more comprehensive set of asks at the end of the presentation and ask that you contact your legislator to help us with this. But we're asking the legislature, for heaven's sakes, if you can put a limit of 72 hours in a year, if that's a limit that you can use, an employer is willing to give that full 72 hours up front, can't we just skip the accruals? Right now, the answer is no, you can't skip the accruals. What we want to change the law so that the answer will become yes. All right, so what is the accrual for hourly and salaried employees? And essentially, and there is a difference here. Okay, so, and this is a little bit of an asterisk of what I just said. So if you have, think instead of, I always hesitate to say hourly versus salaried. I'd rather talk in terms of exempt versus non-exempt. So just because somebody is salaried doesn't mean they're necessarily exempt from overtime, overtime rights. So it's, if somebody is exempt from the Fair Labor Standard Act, so the exempt from receiving overtime, that's usually going to be your salaried employees. You may, for them, kind of set a fixed accrual. You can just assume every work week is 40 hours, or if their normal work week is 35 hours or 30 hours or whatever. If they are salaried, exempt from the Fair Labor Standards Act, then you can just set, here's the regular work week, here's the automatic accrual that's always tied to that, set it and forget it. So you're still technically doing the accruals, but you're not like keeping track exactly of when they worked and when they're on and when they're off and then doing it. But for those who are not non-exempt from the, in other words, subject to the Fair Labor Standard Act, entitled to overtime, in other words, those employees, you have to keep track of how much they're working. And even if you front end load, you have to be able to prove that the amount that you front end loaded was adequate to meet the amount that they actually earned under this law. So it's one of these things where it's like, yes, you can front end load, but you have to be able to prove it. There's ever a dispute, you as the employer, going back 3 years, have to be able to prove that the amount actually worked met the requirements of the accrual requirements of this act. Unless you actually keep track of how much they work and do the accrual, how would you know? It's like that for hourly non-exempt employees, and for salaried exempt, you can set a certain amount and you don't have to keep much track of how much they normally worked. All right. The when is the employee able to draw or to use it? And this is different. So remember, the accrual starts on day one of their employee with you. When can the employee actually use it? You as the employer may institute a 90-day waiting period, but this is 90 calendar days. It's not 90 working days or 90 scheduled days or whatever. It's just you count out on the calendar. They started work from you on this date, count out 90 days. At the 90 days is when they can start using the benefit. By law, you can't make it any longer than that. So accrual starts on day one, use on day 90. So, and it is on the 90th day, not the 91st day. I don't know if that's going to matter that much to you, but all right, next slide. So we're going to get into some things that are a little bit more difficult now. So I apologize ahead of time. Hopefully you all took your blood pressure medicine today, because some of these things get really difficult to deal with. They're going to be very difficult to deal with if we don't get some relief from the legislature. So this question on increments, how often, like if somebody uses sick time, can you require it to be in bigger blocks instead of little blocks? And the law says that you cannot make the required blocks of time that they use it any bigger than 1 hour. Okay, so it sets a minimum that you can't, or I guess a maximum. You can't require that they use it in any more than 1 hour. A lot of employers' handbooks say that if you're going to use sick time, then you need to use it at least 4 hours at a time or 8 hours. And this is usually to avoid it being abused to cover just like tardiness, for example, where somebody's, I'm going to use it. I was 15 minutes late for work. Oh, I'm going to use my sick time to cover that. I was half an hour late for work. I'm going to use my sick time to cover that. Under the way that this law is developed, they say that you can't set increments any less than 1 hour. However, Employer, if your time and attendance and tracking payroll system is able to recognize and keep track of time in increments smaller than 1 hour, then you must let employees use sick time in those smaller increments. And so they give an example. This is the state's example in the second bullet point here. Not this, these aren't my words, these are the state's words. For example, if an employer uses 1/10 or 6-minute increments of an hour for tracking time and absences, then this would be the increment use allowed for earned sick time. So naturally, the concern here is that if 72 hours is what, kind of average full-time worker is going to be able to use of this benefit over the course of a year, then, well, they could be a half an hour late for work 144 times a year. And as long as they say I'm using sick time, you as the employer would be prohibited from taking any corrective action with respect to that. So this is another one that we would like for employers to be able to require larger increments, 4-hour increments, to say, if you're going to use sick time, you have to use it in bigger blocks so that if it does get abused, the number of times it could be abused is limited. So, there are definitely some obvious problems with this, but it goes down. I saw a question pop up, and I'll just address it right now. Does this mean if you've got a punch clock and it keeps track by the minute, you have to let a person take sick time by the minute? Yes, that is exactly what this says, and it's why it's so unreasonable. So if you have a punch clock that literally says that somebody clocked in at 8:02. Or let's say somebody's shift starts at 8 o'clock and they clocked in at 8:17, and they say, I want to use sick time. I want to use 17 minutes of sick time. They can, under the way that this is written. That's exactly what that means, down to the minute, if your system can keep track to the minute. Okay, now when, there's a lot of words on this slide. Okay, so I don't think you really need to kind of study through it because it almost becomes moot because of employees don't have to prove anything. But ultimately, this question, when can an eligible employee use earned sick time? When can they use it? The first bullet point are all the things that you would expect. The employee or an employee's family members, mental or physical illness, injury, health condition, medical diagnosis, care, treatment, all that kind of stuff is included in there. They've added things like if somebody is assaulted, physical or sexual assault, domestic violence, that sort of thing. Sick time it's an entitlement for those sorts of things too. Naturally, most employers would allow it to be used for that anyway. So there is but this fourth sub bullet point down, I want to draw your attention to. So it says, for the closure of an employee's place of business by order of a public official due to a public health emergency. So naturally, your mind would go to, well, it's like the pandemic, right? Remember, this was written before the pandemic. This is from 2018 when this law was originally proposed and written. So I want you to think more like if a place is closed, I'm thinking like a school closes because too high a percentage of the kids have the flu, and they're not going to make their count. They do a count in schools. A certain percentage is absent, doesn't count as a school day for the state's minimum standards. So or maybe a daycare or is closed because some employees were sick, or somebody has a flu at a restaurant. The public health department might say you have to close, do a cleaning protocol or whatever. People can use it for those types of benefits. One thing though, it does tie to here a decision by a public official, and it ties it to public health, and it even says public health emergency, which I think does limit it some. So I don't think this could be used for, say, the school closed because of a snow day. Like my kids are at home right now. Hopefully the place hasn't burned down by the time I get home. But like there's it's a snow day. I don't think that this wording applies to the school or the daycare being closed because of a snow day. It ties it to public health issues. Before we go to the next slide, I want to redraw your attention to something here. Look at the first bullet point. the employees or the employee's family member's mental or physical illness. So it begs the question, who is a family member? What is the definition of a family member? And that's on the next slide. So who is considered a family member? Naturally, it includes a bunch of issues. All right. So a bunch of things that you would think, oh yeah, naturally, it's kids, every form of kids that you can think of, biological, adopted, foster child, stepchild, legal ward. It even includes an employee stands in local parentis, breaking out the Latin terms here. It's every form of child that you can think of, but naturally that stuff is going to be covered. Parents, any kind of parent, so to take care of your parents, adult parents, and that sort of thing, grandchildren, siblings, biological, foster, adopted. But the state really could have just dropped off those first 4 bullet points because of the last one. The last one says any other individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. So any other individual that is an equivalent of a family relationship. You as the employer, there's no mechanism in this law for you as the employer to apply any sort of value judgment on whether somebody is an equivalent. This is of a family member to your employee. This is whoever your employee designates as the equivalency of a family member counts under this law, the way that it is drafted today. And by the way, it does not appear that it is family members are limited to human beings. So it's any other individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. So I think you could literally use this benefit as an entitlement for to take your dog to the vet, for example. I got a couple dogs. They are like family. They literally sleep in my bed. Like they're but I mean, the way this is written, I think that you could actually qualify that under the law. And I'm trying not to be like overly dramatic about it, but the wording here is so broad that I'm very, very concerned that if the legislature doesn't clean up this language and narrow it down to what paid sick leave would normally be used for, then I think that we are that employers are going to be in a really tough spot as they're trying to implement and solve through this. Naturally, most of your employees are great and they're not going to abuse this, but some will. And so employers are going to be hard pressed, I think, to address problems when they come up. All right, so let's, unfortunately, we haven't even got to the worst part yet. Can an employer require an employee to use other benefits such as vacation time in lieu? So they phrase this question really weird, but let me kind of put it out to what we're really talking about here. Well, we're talking about our general leave banks, general paid time off, PTO banks. Most employers have moved to this. You don't have like vacation time, personal days, sick days like that. It's mostly all in one leave bank. And so the question is, well, what if I give paid time off that exceeds what the accrual requires exceeds the 72 hours? What if I already give 80 hours of overall paid time? They can use it for sick time, for vacation time, whatever they want. Does that count? And the answer is maybe. Maybe it could count, but let's talk about what would have to happen in order for you to count that. Number one, you still have to keep track of the accruals to show that what you're granting is within what the accruals would have given them. Okay, so that's the first thing. But the second thing is, look at this first bullet point. An employer's paid time policies that provide at least the same amounts of time, the same amounts that talk about time as provided by the Act, and can be used for the same purposes under the same conditions. This is where I think that general leave banks are probably going to run into trouble, because your general leave banks today probably require that an employee provide notice and receive approval from their supervisor before they can use the leave time. So it's like, I want to submit in for vacation. I've got 80 hours. I want to put in for 40 hours because I'm going to be gone for a week. You submit that to your supervisor. The supervisor approves it, and the worker uses it. Under this writing here, that doesn't count toward the leave benefit, because you are requiring approval and notice. Under the paid sick leave, you can't require notice and approval before its usage. So when this first bullet point, it says, you can count it as long as it's the same time and it can be used under the same conditions and as the paid sick leave. One of the conditions of the paid sick leave is that you cannot require pre-approval or notice before it's used. And so that's a policy question that, yeah, you maybe could use it, but it's going to be tricky, because how do you say on your general leave bank and vacation time that you can use it without approval or notice from your supervisor? It's going to be very difficult to implement. And so I think that we are this is going to be a particularly difficult thing for employers to deal with. The smaller employers must be the ones that have some paid time and unpaid time. Remember, it's for 1 to 9 employees, it's 40 hours of paid and 32 of unpaid. You have to allow people to use the paid time first before they use the unpaid time for that entitlement. So this is a big one. It's a big issue. We would what we'd like to do is to have the legislature explicitly amend the law to say that employers that offer a greater amount than's required under this law, whether it's vacation time or whatever, and even if it requires pre-approval, that it still counts toward this benefit. But as it's written today, you would have to let workers use the benefit, use that bank of leave without approval or notice for it to count toward this benefit. Now, what will happen, what we're saying to the legislature, is many employers will start to separate out their leave time. They'll say, okay, employees, maybe you've got 120 hours, 3 weeks of vacation or total PTO for whatever reason you want. We're going to separate it out to where 9 days of it is for sick leave and 6 days is for vacation, because of this provision that says that it has to be used under the same conditions, or they have to be able to be allowed to use it under the same conditions. Okay, next slide. We have what is the required wage rate for earned sick time? So for most employees, pretty straightforward, whatever their regular rate of pay is. If it's a tipped worker and and so it's 38, right now it'd be 38% of minimum wage, their rate would automatically jump up to the regular minimum wage, which as of February 21st is going to go to $12.48. So it's a regular minimum wage. The second bullet point is the part that is kind of complicated. And this is where employees might have rates of pay that are variable. Maybe somebody had overtime. Maybe there's a different type of work that they do, and they get paid when they're doing this type of work at one rate and this other type of work at another rate. It could be shift premiums. There's a lot of things that could make changes in a person's rate of pay. So when a person uses sick leave, so let's just go through a scenario, probably the easiest way to define this. A person says, all right, I want to use sick leave, and I'm going to use 8 hours of it. So you as the employer have to decide, how much am I going to put in their paycheck for that 8 hours? If this is an employee that has any variable nature to their pay, what this says you do is you go to the immediately preceding pay period and you calculate their average earnings during that pay period, the immediately preceding pay period to when they're asking for the leave. That's the rate that you use. So when I look at the second bullet point, I'm left with some questions. All right, I think that probably overtime is included in this. So somebody worked overtime, you kind of create an incentive to use sick time in the pay period after you get a lot of overtime. But what about like bonuses and commissions that might happen more infrequently? An annual bonus or monthly commissions or quarterly commissions, that sort of thing. I think that this is where if it's not clear to me that that type of pay figures into this average, but it could, when you could read it that way. If that's the case, then like everybody's going to use sick leave. I mean, there'd be I should put it a different way. There will be a big incentive for employees to use more sick leave right after they receive a bonus or a commission payment, that sort of thing. Big problem with how this is for certain types of work arrangements. I think that this could be problematic for employers who have variable rates of pay for employees. All right, so this is it's kind of a big one because there's a simple answer and then there's a giant exception to that answer, okay? So does accrued unused earned sick time need to be paid upon termination of employment? So somebody quits, somebody retires, somebody gets fired, they have unused sick time in the leave bank. Do you have to pay it? This law does not require that you pay it. It can just fall right off your books. The but the big exception to that, okay, is, and this, here's the homework out of this presentation today. I really want everybody to go look at your employee policy, your employee handbook. There is a separate law from 1978, the Payment of Wages and Fringe Benefit Act. And what this says is that if you have in your employee handbook that you pay, somebody has unused leave, and when they leave your employment, you pay it out, it's like a contract. You have to give that to your employees. So if that is in, if you have a policy today that says in their employee handbook, if you've given your employees and said, hey, if you don't use your vacation time this year and you bank it up, and someday when you leave employment, I'll pay you for it. If you've got that in your employee handbook, then you have to include this in that. Okay, so now I shouldn't say this. I should, like, this is for paid sick leave. If your handbook says that you pay out sick leave when they leave their employment, or PTO that includes sick leave, then you have to include this. So there's still time to fix that. It's not a, certainly not up to me. I have no recommendations on whether or not you choose to pay out unused sick time when somebody leaves your employment. But what I'm saying is don't do it by accident. Okay, so intentionally decide. Look at your handbook and make sure that your handbook, if you don't want to pay this out when somebody leaves your employment, make sure your handbook doesn't say that you're going to pay it out when they leave employment. So that's just something really to make sure that you understand before this goes into effect and you're in the middle of it. All right, does an employee lose accrued hours if laid off, terminated, or transferred? This is a new one. This is a new FAQ that was provided to the state, or provided by the state to employers, and they put a standard in it, and it's 6 months of separation or less. So basically, what this is saying is that if an employee leaves your employment and they permanently leave their employment, well then, yeah, the unused sick time pay just falls off. It goes away. You don't have to pay it out. You don't have to keep it on the books, nothing like that. But if somebody leaves your employment and they come back within 6 months, then you have to let them pick up right where they left off. Okay, so you don't start them back at zero. Whatever was accrued and unused carries over to their employment. So that is that 6 month window is an important one to understand. All right, this is the hardest one. I always feel like I want to apologize to everybody before we get into it. This is the worst one. A lot of words on this slide, but we're talking about here is accountability. So you know that sick leave can be used for almost anybody. It can be used in a whole bunch of different circumstances. But you as the employer, if you feel that the sick leave is being abused, what can you do? And like, what are your rights to make sure that this is being used appropriately? Well, on this set of bullet points, I'm going to focus on the first three, but we got to talk about the third one first, because only after you read the third one can you really appreciate and grasp how meaningless the first two are. The first two sound pretty good, and then you get to the third one and you find out, oh, the first two don't mean anything. They're kind of negated. I say, when I say negated, if you have like a problem situation where somebody's abusing this, here's where I think it's going to come up most often, and where you're really going to be limited in what you can do about it. Third bullet point, for earned sick time of more than 3 consecutive days, 3 consecutive days, not 3 days cumulative, but 3 days in a row. And these would be 3 scheduled days. So if they weren't scheduled on Saturday and Sunday, so I mean, let's talk about the scenario. 3 consecutive days, what does it mean? Somebody's gone on Friday, and they weren't scheduled on Saturday and Sunday, and then they're gone on Monday, and then they're gone on Tuesday, that's 3 consecutive days. Okay, and then the 4th consecutive day in that scenario that I just laid out is Wednesday. Okay, so let's talk about that. Only on the 4th consecutive day can you as the employer, this is the 3rd bullet point, then and only then may you require reasonable documentation. What's reasonable? It's not really defined yet, but any documentation at all. Only on the 4th consecutive day of absences may you as the employer require documentation. Okay, documentation to that the earned sick time has been used for a purpose covered by this act. So what this means is that the first 3 days, they can be gone for 3 consecutive days. You are not entitled to require, you may not require any documentation whatsoever about those 3 consecutive days. So now let's talk about the first 2 bullet points. Okay, the first 2 bullet points. If the need for earned sick time is foreseeable, an employer may require an advance notice not to exceed 7 days. Okay, if it's foreseeable. Now, how do you determine if it's foreseeable or not? If it's an absence less than 3 consecutive days, so you haven't hit the 4th day yet. Well, was it foreseeable or not? That's in the judgment of the employee, because you as the employer are not allowed to require them to prove anything. You can ask, we're going to talk about that next. That's the next slide. You can ask, but but you can't require that they prove anything to the 4th consecutive day. So let me adjust this first bullet point to tell you what I think it really means. If the need for earned sick time is foreseeable in the opinion of the employee, then an employer may require advance notice not to exceed 7 days. See what I'm saying here? That 3rd bullet point means that you really can't require any kind of proof on this until the 4th consecutive day. After the 4th day, then you can. Now let's take a look at the 2nd bullet point. If the need for earned sick time is not foreseeable, an employer may require the employee to give notice of the intention to use sick time as soon as is practical. But again, same problem. When was it practical for them to give you notice? Well, as that's the opinion of the employee, whenever they felt it was practical, because as long as it's 3 days or less. This is why when you hear us say that this law has embedded in it a 3-day no-call, no-show allowance, this is what we're talking about. Somebody cannot show up for 3 days as long as they show up on the 4th day and say, I'm using my earned sick leave, and they had the time available. As long as they say I'm using my earned sick leave, you as the employer, you cannot require them to prove anything. They can say, well, in my opinion, it wasn't foreseeable. In my opinion, it wasn't practical for me to let you know that I was going to be gone the last 3 days. And therefore, I'm protected by this act. And they're right. They are protected by the act in that circumstance. And this is another area we really, really need the legislature to make some changes. Now, we have expressed strong reservations over this section to both the regulators in the government, but also the legislators. Now, to try to alleviate some of that concern, there's the next FAQ. So let's take a look at the next one. May an employer ask questions regarding the need for using earned sick leave? May they ask questions? Well, the answer is yes. You can ask questions. They added this that, yeah, look, an employer can ask questions when using leave under ESTA. This first bullet point, it says employees should provide. It is interesting to me, and I used to work in the government. I worked for the state for 12 years and was very involved in the lawmaking process. And so I pay very attention to words like should, right? There's a decision. They could have said should. They put should in there. They could have put must. They chose not to put must here. So that's an interesting distinction. So let's read it and keep that distinction in mind. When using leave under ESTA, employees should provide sufficient information for the employer to determine whether the leave meets the eligible uses under the Earned Sick Time Act. All right, so what they're saying is an employee should provide sufficient information. But we know from the previous question that whatever sufficient information means, it cannot be a requirement for documentation or proof until the fourth consecutive day. So this does not solve our problem that I articulated on the previous slide. The employees should provide sufficient information to determine whether the use meets the eligible criteria. But you know what this doesn't address? It doesn't address the question of whether or not the use of the sick leave was foreseeable, or if it was practical for them to let you know that they were using it. So even this answer on this slide, it says they should give you an answer. If you ask a verbal question, they should give you a verbal answer to say, yep, I was sick. I'm eligible for it. And you can say, but why didn't you tell me? You didn't call for 3 days, and they just show up on the fourth day. They can still say, even with this, well, it just wasn't foreseeable, and it wasn't practical for me to do that. There's nothing until that fourth consecutive day. You can't require any kind of documentation about that. So you can ask questions, and the employee should provide you information to let you know if the meet was for that the use of the leave was for some eligible purpose. But it's not about whether or not it was foreseeable for them to tell you that they're going to use it, or practical for them to let you know at some point before they just showed up after 3 days. So this is another really big problem. And I mean, I appreciate that they did try to address some of our concerns with this. At least you can ask, and they're saying, yeah, employees should answer to make sure that at least they used it for, yeah, I was sick, or my parents were sick, or my kids were sick, or whatever. But it's not an answer that addresses the no call, no show problem from that I covered in the previous slide. Second bullet point says, if an employer is unsure, they may ask additional questions. So, you can ask questions, the employee could give you an answer, you can ask some follow-up questions, but documentation or proof, not till the fourth consecutive day. So this is a big problem. One of the areas that we're really looking for the legislature, what we're asking for is that an employee must provide notice before the start of their shift unless they are literally incapacitated, meaning like unconscious. Short of something like that, there's no reason why a person can't let the employer know that they're not going to be in. That it just seems like such a minimum thing. Right now, you really can't. You can say that it's your policy as long as the employee feels it was foreseeable, as long as the employee feels that was practical. You can ask questions, but you can't require documentation. Okay, until the fourth consecutive day. Next slide. So does an employer have a duty to maintain the confidentiality of information provided by the employee? Yes, of course you do. We don't spend a lot of time on this. Of course, you already would anyway. If somebody says, I'm using sick time because, I have this health problem, and they told you about it, you have to keep that confidential. And of course, and I know you would anyway. All right, what recourse does an employer have for an employee failing to follow established notice and documentation policies? Another one that, again, I just feel like I should apologize to you as we get into it, is another one that's really problematic here. What they're saying is, if you want to establish something like notice and documentation policies, the state's answer is, you better consult with an attorney to do that. Because notice and documentation requirements are so extensively restricted from the employer that in most cases you just can't do it. So what they're saying is, if you want to try, you better talk to an attorney. And unfortunately, I think that's good advice, because they say that you can't require any documentation until the fourth consecutive day of absence. And if you want to establish a notice requirement, the notice requirement is still really subject to the judgment of the employee. And so your hands are really tied on this. They really drive at this point home in the second bullet point. Employers may not retaliate against an employee, and that's how they look at this, retaliation for engaging in an activity protected by the act. In other words, you can't retaliate against an employee because they used paid sick leave. And to drive it home, what this means, they use the word importantly, and this, all the FAQs, this is the only time they use the word importantly. So I think we should really pay attention to that they want to draw your attention to this. Importantly, there is a rebuttable presumption. Rebuttable presumption means that we're going to believe something is true unless somebody proves that it is false. There is a rebuttable presumption that an employer violated the act if they take any adverse personnel action against an employee within 90 days after the employee engages in a protective activity. The protected activity is using sick leave. Unfortunately, this is so broad. What it's really saying is that there's a two-part test to determine whether or not the employer is presumed to have violated this act. Did you take any adverse personnel action against an employee? Any. Doesn't have to be with respect to time or attendance or sick leave or anything. It could be that they stole money from the till and you fired them. That's adverse personnel action. If you took any adverse personnel action whatsoever, any, and they happen to have used sick leave anytime in the last 90 days of that adverse action, the state is presuming that you took that adverse action in retaliation for them using paid sick leave. It's outrageous. This is another thing that we really desperately need to get changed. Just the fact that there's a rebuttable presumption. Rebuttable presumption means guilty until proven innocent. It's not even our system of government in America, and this is something that we really are insistent that get changed in this law moving forward. All right, what are the record-keeping acts requirements under the act? You have to keep records for 3 years, and this is an important one. If there is an employee has 3 years to file a complaint. So if the employer doesn't have records to show that you were doing it right, somebody says, I didn't get all the paid sick leave that I was entitled to. If the employer does not have records showing here's the hours that were worked in the paid sick leave that was granted in connection to that, it is automatically a finding against the employer. The employee doesn't have to prove anything. All of the burden, and this is interlaced through this law, is on the employer. You must be able to prove that you did it right, and you have to keep those records for 3 years. So just, you might already keep records like this for 3 years, but now it's going to be very precise about accruals. And, I think I've heard some employers that are like, for some employees that there's no punch clock. So the record is going to be, I want every employee each week to report exactly how many hours. So it's at least their, it's them saying it. So you can look at it. As long as you do the accrual math right, you're good. And you got the record showing the employee said, here's the number of hours that I worked. You can't go back later and say, well, you didn't, the employer shorted me some. That was their hours reported in some direct way. Procedures like that are going to be necessary in the future, unfortunately. All right, is there a posting and notice requirement? Yes, you are going to have to give before February 21st. You have to notify your employees of these new rights that they have. And then there's also going to be a posting requirement at the requirement at the place of business. And that's kind of, so we're going to need a little more definition on that. What if you have multiple locations? What if somebody's, full-time remote? What's the posting requirement on that, or how they gonna handle that? But that will be that they have provided notice contents at michigan.gov/wage hour. So they're telling you what needs to be in these notices. So you'll have to send those out later on as we get closer. All right, we're getting close here to the end. What remedy is available to employees? I only include this one because, we're going over all of the FAQs, but this one really is for employees, not employers. But you may file a claim with the Wage and Hour Division if an employee feels they've been shorted. You have 3 years from the time of the alleged violation, and then they do an investigation. They may choose to do mediation. Um, the department itself, the Wage and Hour Division, the department can decide relief. If they feel there's a violation, the department may award relief, and that relief could be payment of earned sick time that somebody was entitled to, or in their words here, improperly withheld. It could be to assess damages that were incurred as a result of the violation, and they could even reinstate somebody to your payroll that you let go. There's a heavy hand. They got a heavy hand on this. And this is just what the department can do. The workers also can go directly to court on it. They have a private right of action in this as well. These are also things that we hopeful that the legislature will change before they adjourn the lame duck session. All right, we're getting close, folks. I know there's a lot of questions here too that will I can stay on here for a while and answer. There are penalties. You can see what they are. Just keep in mind they're penalty per violation. So if there was a complaint later on and the department said, you've been doing the accruals wrong for every worker in every paycheck for the last 2 years, you can see how these fines would really add up to a lot. Okay, things that we're looking for to get changed. Employers with paid, so if you're already giving more than 72 hours a year, like we think you ought to be exempt from this law, or ought to be able to count that toward the requirements of the law without having to meet all the conditions of it. The accruals, the lack of being able to require notice or supervisor approval, that sort of thing. We do want a small employer exemption on this. We feel that 50 makes sense. That's what's in Michigan law currently. That's also the Family Medical Leave Act has a 50 employee exemption. So if you're 50 or more, you're in, and if you're 50 under, you're just exempt altogether from the law. That is something that we're vigorously asking for here. Time should be time uses. We want employers to be able to say, look, if you're going to use sick time, it has to be in a 4-hour increment or even a 1-day increment. If somebody's really sick, probably ought to be out the whole day, not just the first 30 minutes. This could help it reduce the instances that could be abused for tardiness, for example. And then also require notification prior to the start of the shift unless the employee is literally incapacitated. The act allows employees to sue businesses and then automatically assumes in any sort of action like this that the employer is in the wrong unless they're proved right. We would rather have just the Wage and Hour Division handle this and not have it be something that can go directly to court. But then also it's very expensive. Employers are in a position where even if they win in court, they lose because it's so expensive. But we also want to remove all of the rebuttable presumptions in it. If there's a complaint, let the department investigate the complaint, consider the facts, and make a finding. There's no reason to presume the guilt of the employer on the front end. That's just not a reasonable position. It's un-American. So and then the last one here, there are some other kind of asks as well, but the last one here is to allow front loading and then relieve the employee from the employer from having to do accruals. So give the full amount that somebody could use up front, and then say to the employers, you're relieved from the obligation of doing accruals. We think that these are very, very reasonable asks. I'm going to go to the next slide that has a QR code on it. If you have not already, I'm asking you, please follow this QR code and participate in our call to action. What it does is it says to the legislature, the House, the Senate, and the governor, we need these things changed. And it lays out these changes I just mentioned, what SBAM and some other business associations have zeroed in on, where We think they're very reasonable and modest changes to be made. We know that repeal of the act is something that this legislature and this governor would never agree to, but they ought to at least make these changes to make it possible to operate a business in the meantime. They make it so difficult under this law. So when I take some questions, again, I see we still have well over 200 people on. I'll hang out here and take some questions, and but this whole recording is available to you. The slideshow is available to you. Actually, Sarah, do you want to leave that QR code up just as a reminder of people if they hadn't gotten to it yet? See if we can get some of those calls to action done while we're taking questions. All right. I don't know if Jacob or Sarah, if you want to maybe give me a few, just throw out a few of the questions that you think maybe haven't been answered yet.
Yeah. Thank you everybody for sending your questions in the chat and in the Q&A section. We've had a lot of people asking a lot of really great questions, and I've tried to answer as many of those as I can, but it's just a lot of volume and some that are unanswered too. So I have a couple here for you, Brian, that I set aside. We had a couple people ask, are owners counted in the number of employees if owners receive a W-2?
Yes. Yeah, so if you are an owner and you're paying yourself with a W-2 as opposed to, distributions from, LLC, distributions on a K-9 or something, you're an employee. So you are in the head count as an owner. It's just one of those kind of intricacies. So if you're right on that bubble, you might want to think about not treating yourself like an employee. But there's other trade-offs, as you probably well know, is that I don't know if you'd ever use unemployment benefits or something like that, but if you're not an employee, and I know that, with other issues with federal or retirement benefits, that there might be some reasons why you'd want a W-2. But yes, you are in the head count.
We've had a couple people ask if we use one bank of PTO for vacation, sick time, other, that meets all of the requirements of ESTA, an employee opts to use the entire bank for vacation, are we then still obligated to provide sick time?
Yeah, and this is complex and it is situation specific. So let's just kind of break this down a little bit. In this case, you could potentially count that as the ESTA benefit. Okay, but if your policies say that leave bank requires pre-approval and notice in order to use it, I think according to the state's FAQs here, that an employee could file a complaint and say, I think I was entitled to these other 9 days of sick leave. I used my 10 days of vacation time, and my employer is saying that counts, but they made me get pre-approval from my supervisor, and I had to provide notice and get pre-approval, and therefore it doesn't meet the same terms and conditions of sick time. Therefore, that leave bank doesn't count toward my sick time. I think that's the risk that employers are taking by using the vacation time as the counting toward the leave bank. Now, let's say you've got a situation where you said, yep, I'm going to figure out how to make that work, that an employee could use that leave bank without notice or approval, and therefore I'm going to count it toward my earned sick time. And then the employee used it all for vacation and didn't use any for sick time. I think you're good in that case. I think in that case, as long as you are allowing your general PTO bank to be used in the same terms and conditions, which means they could use it without notice or approval, then the fact that they used it all up on things that weren't being sick, I think you're still good. I believe that the state has opened the door to that. In fact, I'll go so far as to say, I think that even the people that are charged with regulating this, they think that general leave banks ought to just generally be counted toward it, but I think they're a little bit handcuffed by what this law says in terms of how far they can go with that. So what they're saying is it has to be used for the same terms and conditions. So could you set up a policy? Let me give you another one with the asterisk. I am not a lawyer, but one thing you might want to explore is I'm going to have a leave bank and say, okay, this entire leave bank could be used for sick time. It could also be used for vacation time. If you want to use it for vacation time, you have to give me notice and approval. If you want to use it for sick time, you don't have to give me notice or approval. In that scenario, you might be able to use the same bank and kind of have your cake and eat it too. I'm only putting, the only reason I put that asterisk out there that I'm not a lawyer is because I don't know for sure that they would accept it. When I read their answers, I think that fits all, it checks the boxes that they put in their FAQs. But nobody's done it yet, and nobody's complained, and there's been no administrative hearing to settle dispute on it. So I don't know how the regulators would decide at the end of the day, but I think it's possible that you could set up your policies in a way to use your general leave bank to count toward that, toward this requirement.
We had two questions that kind of go together. We had one person ask, aside from writing our legislators, are there any hearings, et cetera, that we can do to get involved to help manage this this issue? And then we also had somebody ask if any of the bills being considered include any of our requested changes.
Yeah, great question. So there are two bills, one for the minimum wage and one for the earned sick time requirements. Two different pieces of legislation. They were introduced in the House of Representatives. Right now, those bills are what we call shell bills. They don't have much in them. What they do is they open up the public acts that are relevant to this issue, and they're just sitting there right now. There are negotiations happening, and I can tell you that these requests that we've made, they are being taken seriously. And I think there is some chance that they will adopt them. But they haven't been like put into the bills yet because it's still being negotiated. There's a bunch of things being negotiated. All this stuff is connected. So they want to expand workers' comp rights for workers. They want to increase weekly benefit for unemployment. They've got all these different things that they want to bring back. Some of them want to bring back local minimum wages. So like there's so many different aspects on the table, and they're all kind of interconnected. So there's a lot of negotiating happening, but none of it's actually like in a committee. And that's what makes it it's not the sort of thing where you can see it or kind of get at it right now. And so what can you do aside from this call to action? Please do the call to action. That really makes it. We've had more than 2,000 contacts into public officials on this call to action, which is huge. That just makes such a big difference. Thank you for doing it. What else can you do? There's not a committee at the moment scheduled, and I think they won't schedule a committee until they have a deal and they know what they're going to do and they're going to run it through, and testifying committee won't matter at that point. So what can you do? Do you know your legislator? Even if you don't know him or her, please reach out to them directly. It's one thing like this call to action, it sends an email to their district inbox. They'll get a big flood of them, even just from us. It's been a lot. So they know this is a big issue. A lot of people thinking about it, but also a call or a text, especially if you know somebody personally, to say, hey, listen, we really, really need you to do this. That could go a long way. By the way, if you do that, would you let us know what they say? Because sometimes they'll tell their constituents a little more than what they'll tell us. So it's good to know what they're telling their constituents. So when you do a call to action, send an email, or you make a call, or you text. If you know them well enough, you got their number, you text them. Then if they respond back, would you let us know what they say? That would be, whether it's like, hey, we're with you, that would be good to know. If it's like, I don't, no way, here's how I look at this, then, that's just how it is. I see this question about the, timeline too, that really, if it happens before the end of the year, I think it'll be the next 2 weeks. So we've got a couple of weeks in front of us where they're likely to be in session, what's called lame duck session. So we've got the existing legislature that's in place, but we already had an election in November to be a new legislature in January. Getting up and running in January takes a while. So I'm afraid that if it doesn't happen in December, these amendments don't happen in December, then before it can go through the process and get approved, any potential changes next year, this will go into effect. Doesn't mean it couldn't still change in the future, but it would be a real pain to have to implement it and then have it change after you had to implement it. So I think in the next 2 weeks, actually by next week, we'll probably have a pretty good idea of what's going to happen. But just the way the legislative procedure works, it would take a couple of weeks for it to actually go through the whole process.
So building on that, Brian, would you say, we had somebody in the Q&A chat ask, when will we know what is final and when should we start making changes to our handbook and policies?
Yeah, so how complex is your operation and how quickly can you move is part of this. But let me speak in general terms. I can tell you, I mean, I'm a CEO of the Small Business Association of Michigan. There are 37 of us who work here. So this is something that we will have to comply with. I do not intend to make any changes to policy effective before February 21st. So that's how I'm looking at it. Like, I'm not going to proactively change something before it's required in the law. So February 21st is when we would change it. Now, when you kind of back up, like there are certain things that have to happen before it can be implemented. Really, for me, what that means is that as soon as we know, as soon as we have an idea, and by the way, we'll tell all our members, as soon as we feel confident, like, hey, here's how we think this is going to turn out, we will let you know. But as soon as I feel confident, we'll start implementation here. I mean, we won't make it effective, but all the things, here's what we're going to have to do for time and tracking. Here's how we're going to do the accruals. Here are policy changes we need to make to vacation time and all that kind of stuff. That we'll start that as soon as we have a really good picture of what the legislature is going to do. So I think within 2 weeks, we'll know that. Immediately after we know what's going to happen, we'll start the implementation phase of it. And then I don't intend to make it effective. I don't see any reason why to make it effective before February 21st.
Okay, and I think that is probably a good place to leave it off, Brian. There are so many unanswered questions here in the chat, and for each one of these, we encourage you to, reach out if you have any pressing questions. And I know Michelle from our team also posted a link to our Ask an Expert resource in the chat as well. But I do believe that is all we have time for.
Great. All right. Thank you so much, guys. I appreciate you being on it. If you are a premium level member or higher, you have the Ask an Expert, follow that link. If you never check that out, do, because not just for HR, you could use it for legal. There's good stuff for cyber and IT issues. So that's a service that is available to you. Also, we have an email, sbam@sbam.org. If you got a question in there, we're not always going to be able to answer really specific things that are very, very specific to just your business. Here's how you're operating. We can give you an idea of how we think, but we won't be able to answer every particular question that's not really policy based. But I appreciate you being a part of this. This recording will be available to you, and please stay tuned for messages from SBAM. This is a very fluid issue, and we will stay, I promise you, this is our top priority, and we will stay on top of it.